Ever signed a lease? Maybe started a business, with a partner. Or even just clicked I agree online.
Oh, yeah, we've all done it.
And often you're so focused on the main thing, getting the flat, launching the company, that your eyes just sort of glaze over the fine print.
Totally. Especially when you hit those bits that look like, well, like legal code or something.
Exactly. Ever just breezed past stuff like that?
Absolutely. And buried in those paragraphs, particularly if you're dealing with South African agreements, there's often this term. It holds quite a bit of weight. Domicilium Citandi et Executandi.
Whoa, that's a mouthful.
It is, isn't it? Sounds incredibly official.
But underneath all that Latin, there's actually a really practical concept, right?
Precisely.
So for this deep dive, that's what we're tackling. Domicilium Citandi et Executandi. Our mission really is to decode it, to help you understand why it pops up so often in South African contracts.
And crucially, how it can genuinely affect your rights and your responsibilities, too.
Yeah, exactly. And look, we're drawing our insights today from the folks at Jonker Vorster Attorneys. They're specialists in this stuff, deal with it day in, day out.
Right. So let's unpack this domicilium term. In simple language, and this is how the legal experts at Jonker Vorster explain it, it's basically the address you officially choose for getting all formal legal messages.
Okay, so like your designated legal post box.
Kind of, yeah, think of it that way. It's the spot where the law assumes you'll accept notices.
Right. So it's not just like any old address you write down. It's the specific one you nominate.
Mm-hmm.
And here's the kicker, isn't it?
Mm-hmm.
Once you've picked it, that address is, well, it's binding.
It really is. The source material stresses this point hard. Even if you personally don't actually see a document that gets sent there.
You mean like if you moved or something?
Exactly, or you're away, it doesn't matter. Legally, it's considered served or delivered. South African courts really rely on this chosen address. It's about making sure legal processes can actually happen without people just dodging notices. Create stability.
Okay, wow. That's quite powerful. So having this domicilium clause in an agreement, why is it so standard? What are the upsides?
Well, number one, it creates certainty. Simple as that. Both parties know exactly where to send the important legal stuff.
So no arguments later like, oh, I sent it to your old office or whatever.
Precisely, which leads to the second point, efficiency. It just cuts out potential disputes about whether someone actually received a notice.
Makes sense. But you mentioned responsibilities earlier. The lawyers also highlight it's protective, but maybe risky too.
Yeah, it's a double-edged sword in a way. It protects the process, ensures things can move forward, but the risk for you is that if something gets sent to that official address and you ignore it,
Even if you genuinely didn't see it.
even then, legal action can proceed. Because, as we said, the courts recognize delivery to that chosen address as valid legal service.
Yeah.
It can have pretty big consequences if you're not on top of it.
Okay, so choosing this address needs some thought then.
Yeah.
What are the actual rules? Can I just pick my holiday cabin address?
Probably not. The absolute main rule is it must be a physical address, a street address.
Not a P.O. box.
Definitely not a P.O. box. Legal practice requires a verifiable physical location. Somewhere you are, as the source material puts it, reasonably reachable.
Reasonably reachable. Okay.
P.O. boxes just don't cut it for formal legal service. Too hard to confirm receipt,
Right, right. But life happens. People move. Can you change this address once it's in the contract?
Often, yes. Most contracts will likely have a clause about it. But, and this is key, you have to follow the exact steps laid out in the agreement.
So you can't just send a quick email saying, hey, I've moved.
Probably not, no.
Yeah.
The attorneys stress it usually requires formal written notice, sent in the way the contract specifies. Could be registered mail, specific timings, that sort of thing.
Got it. So check the contract first.
Yeah.
Always. And what kinds of places do work? You mentioned physical.
Yeah, the common ones the legal experts mention are like your home address, your actual place of business.
Or maybe your lawyer's office.
That too, yes. Your attorney's office can often be used. The main thing is it's a real physical place someone can actually go to deliver documents.
Okay. Now, we've kind of hinted at the dangers, but let's be blunt. What happens if you drop the ball? If you don't keep this Domicilium Citandi et Executandi up to date, what are the real-world consequences?
They can be pretty serious, actually. As Jonker Vorster's material highlights, you could completely miss a court summons. or other vital legal notices, a demand letter maybe.
And if you miss those?
Well, that could lead straight to something called a default judgment. That's where the court rules against you simply because you didn't show up or respond.
Because you never got the notice.
Exactly. You might not even know a case exists until, bam, there's a judgment against you. Maybe your bank account gets frozen, or worse.
Wow. That is incredibly risky. It feels like one tiny detail in a long contract, but messing it up could mean you lose your chance to even argue your side.
That's precisely it, and that's why the attorneys really hammer this home. Managing your domicilium properly is fundamentally about protecting your right to defend yourself legally.
If you don't get the notice, the proper service of process, as they call it.
Then that right is basically gone, compromised severely.
Okay, so let's say you have moved, and you do need to change your domicilium. What's the drill? Step by step.
First step, absolutely critical. Dig out that original contract, read the clause about the domicilium and about giving notices. Does it allow changes? What's the exact process it demands?
Assume it does allow changes. Then what?
Then you need to give formal written notice to the other party, following the contract's rules to the letter.
And like you said, probably not just an email.
Highly unlikely to be sufficient on its own, unless the contract specifically says so, which is rare for this. It often specifies how notice must be sent, maybe registered post, maybe hand delivery. There might be time frames too.
Okay. And the new address you give them.
Has to be another physical address, of course. A street address where you're reasonably reachable. The big takeaway here is check your agreements before you move or change your main address. Make updating your domicilium part of your moving checklist.
That's really practical advice. It all sounds very important in theory, but does the source material give us, like, a story, a concrete example of this going wrong?
Yes, they do. A very clear one. Imagine you sign a lease for an apartment. You nominate that apartment as your domicilium address in the lease agreement. Makes sense at the time.
Right.
Then, maybe a year later, you move out. But you forget, or just don't bother, to formally update your domicilium with the landlord according to the lease terms.
Okay.
Now, let's say the landlord believes you breached the lease somehow after moving out, maybe damages, unpaid final bills, whatever. They send a formal notice of breach, maybe even a summons, to your old address, the one in the contract.
The one you nominated,
Yeah.
but you're not there anymore.
Exactly. You never see it, you don't respond, because how could you? So the landlord goes to court and potentially gets a default judgment against you.
Ouch. And the law would likely say,
The law, as Jonker Vorster points out, will likely consider the service valid because it was sent to the officially nominated address as per the agreement, even though you didn't personally receive it.
that really drives the point home. The consequences are real.
They are. And to clear up some other common points, the attorneys also put together a kind of FAQ in their material.
Oh, useful. Like what?
Well, they state very clearly again, you cannot use a postal address, no P.O. boxes for your domicilium.
Right, we covered that. Physical only. What else?
They directly address the risk of not updating after moving. They reiterate, just like in the example, that this failure can lead to missed notices and serious legal consequences. It's not a minor oversight.
Okay. And changing it. Can you always change it?
Their answer is, it depends entirely on the contract. You have to check the specific terms. Some agreements might be flexible, others might be very strict, or even not allow changes easily.
So again, read the contract. What about email? We live in a digital age. Surely you could just use an email address now.
Yeah, you'd think so, wouldn't you? But the legal experts are quite firm on this. Generally, no. An email address is not usually acceptable as a formal Domicilium Citandi et Executandi.
Why not? Too easy to miss, maybe. Or hard to prove delivery.
Probably a combination of factors. The legal system, especially for formal service of documents like summonses, still largely relies on the certainty of a physical address for proof of delivery. Email just doesn't quite meet that standard legally, in most cases for this specific purpose.
Interesting. Okay. And one last thing from their FAQs. Why are lawyers always so insistent on putting these clauses in contracts in the first place?
Their perspective is pretty straightforward. Lawyers want these clauses for legal certainty and for efficiency.
Certainty and efficiency.
Exactly. It removes any doubt about where legally binding notices should be sent and received. It just streamlines the whole formal communication process if things ever get contentious, avoids arguments about service.
Okay, so wrapping this up then, the big message seems crystal clear. This Domicilium Citandi et Executandi, it's not just fancy Latin to skip over.
Not at all. Understanding it, managing it properly, It's absolutely vital if you're signing any kind of formal agreement in South Africa. It's not just a formality, it's a practical necessity for protecting yourself.
Definitely not just a box-ticking exercise.
Precisely. Making sure that address is right, making sure you update it if needed according to the contract. It's fundamental. It safeguards your ability to actually respond if legal issues arise. It could save you a world of trouble down the line.
This has been genuinely enlightening. Makes you think back, doesn't it?
Yeah.
So maybe a final thought for you listening right now. Cast your mind back over the agreements you've signed. Leases, maybe employment contracts, business partnerships, even those long online terms and conditions you probably scrolled through.
Do you actually remember nominating a domicilium address? Do you know what address you put down? And crucially, is it still correct today?
Yeah. What steps might you need to take right now, perhaps, to make sure you haven't overlooked this pretty vital detail? Something to definitely mull over. And remember, if you need more detailed info on contract law or legal compliance in this area, the insights we talked about today came from the specialists at Jonker Vorster Attorneys.